Have bizarre lease clauses ever caused landmark court cases? Imagine signing a lease and discovering a clause that seems straight out of a comedy sketch. Could such strange language actually lead to big legal battles? Well, it has. Some lease clauses so unusual or extreme have sparked court cases that changed property law forever. These cases show how what's written in a lease really matters, especially when disputes arise over tenant rights or lease violations. One famous case is 50 States Management Corporation versus Pioneer Auto Parks. This case happened in New York in 1979. The lease had a clause saying that if the tenant defaulted once, the entire rent for the whole lease period was due immediately. The landlord wanted to enforce this harsh rule, but the court had to decide if it was fair and legal. The court ruled that even if a lease clause seems tough or unusual, courts will enforce what the parties agreed to if it's clear in the contract. This case set an important precedent for commercial leases, showing that aggressive clauses can be upheld if properly written. Another case involved Vermont Teddy Bear Company. This case reinforced that lease language is what counts in court. If a lease says one thing, courts will interpret it based on the actual words, not what the landlord or tenant might have hoped or intended. This means that confusing or bizarre lease clauses can be challenged if they are unclear or unfair. There is also the case of Greenblatt versus Zimmerman from 1909. It introduced the idea of practical construction. This means courts look at how landlords and tenants actually behaved under the lease over time. If a landlord suddenly changes how they interpret a lease clause, courts usually won't allow that change. This protects tenants from unfair surprises and inconsistent enforcement. More recently, in Quinn versus LMC, the lease had a strange clause that said no other occupants could stay in the apartment for more than 14 days in a row without written approval. It also said no one not listed on the lease could stay more than 28 days in a month. The court decided that such clauses cannot take away the rights of roommates or family members who live in the apartment regularly. This case showed courts won't let landlords use odd lease language to deny tenant protections. The case of Ye versus Escondido involved rent control laws. It asked whether a lease clause that limits rent increases actually transfers a property right from the landlord to the tenant. The court found that lease terms must work within local laws, and some clauses may be invalid if they violate tenant rights or public policies. These cases teach us that lease language must be clear and fair. Courts will interpret what's written and look at how the lease has been used over time. If a clause is bizarre or overly restrictive, it might not be enforced and could even lead to legal trouble for landlords. The best leases are straightforward, respecting tenant rights and avoiding confusing or extreme language that courts might scrutinize later. So yes, strange lease clauses have caused landmark cases, and they reminded everyone that what's written in a lease really does matter.